Good morning, Council. We're here on our next case in Guardianship of Bakhtiar. Are you folks ready to proceed at this point in time?
Yes, sir.
All right, thank you. You know each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Would you like to reserve some time?
Yes, 3 minutes, John.
2?
3.
3. Very good. I will keep track up here, and I'll try to let you know about a minute or so when your time is getting close to being up.
Thank you, Your Honor.
The arguments are being recorded. Please make sure you introduce yourself when you start. You stay behind the podium so we can record you well, and you speak loud enough so the recording picks you up.
Thank you.
You should not use the name of any children, minors, or other victims in this case if that would be applicable in this matter. Please refer to them by their initials or something else. We have read your briefs and are ready to proceed whenever you want.
Thank you, Your Honor. Good morning. My name is Paul Flowers. I represent the attorney appellants in this case, Chuck Longo and Gregory Gibson. Mr. Gibson is here, and unfortunately, Mr. Longo could not attend. I just filed my notice of appearance on Monday and got involved in this, and it's obviously a very sad situation with the family battling over fortunate circumstances, and there is quite a bit of money involved as well. I'm not going to go through the entire history of the case, which is now 10 years long, but the part that's important here is that a motion for sanctions was filed in May of 2021 against my clients, Mr. Longo and Mr. Gibson. They represented only one of the children of the ward, and his name was Cashier Sagafai. He goes more by Cash Sagafai. And we had a hearing on the motion for fees in November. It sat for quite a long time, and it was finally granted just about almost 2 years after it was filed. The sanctions were awarded against my clients under RC 2323.51 and Civil Rule 11. We have 3 assignments of error, and the first one addresses subject matter jurisdiction, and just getting into this a little bit, this really jumped out at me, because this guardianship has been poorly handled, contrary to the statutes from its very inception. Guardianships are an extreme judicial form of relief. They are heavily regulated by statute. The probate court has only the jurisdiction that is conferred by those statutes. And because we're taking away someone's freedom and putting someone in charge of their money, their finances, there are very rigid notice requirements that must be satisfied. And these are set forth in RC 211.04A2 when we're dealing with a guardianship. And for the hearing appointing the guardian, there has to be a notice that is personally delivered to the proposed ward, the putative ward. The notice has to be bold-faced type. It has to warn of the hearing at least 7 days in advance. It has to disclose the right to counsel. It has to disclose the right to contest. It is very specific what has to be in that notice.
Counsel, are you really arguing subject matter jurisdiction or personal jurisdiction? What are you arguing?
Yeah, good question. I believe it's subject matter jurisdiction because of the way the statute is written. It comes out and it says the guardian shall not be appointed until this happens. So it's the General Assembly's control over the probate court. And as I indicated, probate courts are a creature of statute. They only have the jurisdiction that the statute confers upon them. And so the cases that support this are In re Guardianship of Corliss, which came out of the 12th District in 1951, and In re Guardianship of Swartz, which came out of the 3rd District in 2011. They make it very clear that this is not an option. This is subject matter jurisdiction, that this notice goes to the ward in a timely fashion and has all of the languages required by statute in bold-faced type. And I've yet to see that. I've yet to see anything indicating that before this guardian was appointed, that was actually served upon the ward. And it's pretty clear that, to me, it isn't. Looking at the defendants, they're not the defendants, they're the guardian, former guardian. Looking at their brief, the only explanation they offer for how service was accomplished in accordance with the statutes is on page 6, I'm quoting. The probate court investigator, Paula Strickler, served the ward with the guardianship application and notice of hearing at least 7 days prior to the initial hearing in June 2013 and filed a return of such service on May 30, 2013. That's just not historically possible. It just doesn't make sense. Because at that point in time, that's the very inception of all this, the very inception of the guardianship application. There's no hearing that I saw in June of 2013, but we do have an order that appoints an interim guardian on an emergency basis. And the guardian is absolutely correct. They don't have to file the formal notice requirements for that. They do have to file the other part of the statute, which it follows, which is 211.02B2. That interim guardianship is only supposed to last for 15 days. And the court is supposed to issue an order specifying exactly why they impose that guardianship on an interim basis without notice to the ward. Then it can be extended for 30 days, but I didn't see any indication of that. And what's really crazy about this is that if you go by their brief, their historical description of what happened here, this goes way past 15 days. I mean, they go into November, so now we're 5 months in, then they have a hearing. And then another guardian is appointed on an interim basis, purely interim, so it should be another 14 days. Then we go all the way, almost a year later, to October 23, 2014, and finally we get our first permanent guardian. So even in this very inception, there are big jurisdictional problems because, one, we don't see that notice that was required to be personally served on the ward 7 days prior to the hearing. And then we have guardians who are only authorized to be in that position for 14 days, yet it's well over a year that they're in charge of the ward. And this doesn't seem to be a concern to anybody until my clients get involved. So we have the divorce, it's been up and down through here, it's been through the court systems. It goes to federal court because there was the issue of splitting up the ERISA plan. That's when Mr. Gibson and Mr. Longo get involved. And it's at that point that they start raising this jurisdictional question. And yes, they raise it a lot. They raise it repeatedly. They raise it over and over and over because, I mean, as I'm looking at it, they're right. The court didn't comply with the statute. It all seemed to be this kind of like, well, you know, she's got a lawyer, she knows about it, she wants to be with her daughter, all this kind of stuff without complying with the statute. And if you tried that in the civil world, with a civil complaint, that would never fly. I mean, under the Gleason
Yeah, but
case.
at some point, isn't it decided by the court?
Correct.
And at some point, if you argue again and again after it's been decided, isn't that problematic?
No, I can't agree with that, Your Honor. You gotta stick to your guns. This is my philosophy.
When the remedies have been exhausted, that's what I'm saying.
Well, I'm not sure the remedies were exhausted, and I think they were doing the court a favor. I think the court should have corrected this early on, and if they'd taken this seriously, they would have. And my clients are obviously very frustrated because it's just not getting through, the problems with this. And the problems where then you get to the divorce, and then the guardian and the probate court authorizes the divorce, but then how did the divorce have authority then if the probate court didn't? And every step of the way, it was a big problem. That's why I had to keep getting repeated. And you know, there really weren't opportunities to get that issue to this court because there wasn't anything to appeal. Mr. Longo and Mr. Gibson did try to get it to the House Supreme Court in that original action. That was dismissed, but they never got to the merits on that. It was dismissed, I think, probably most likely because there was an adequate affirmative law, which is this proceeding here. So, first and foremost, the probate court didn't have jurisdiction to issue sanctions in the first place because it didn't have jurisdiction over the entire proceeding as required by that statute. If you get past that and you say, yes, they did, you did have jurisdiction, was it frivolous? And that goes to the second assignment of error. And it's a legitimate argument. And there's nothing wrong with repeating an argument over and over as long as it's legitimate and you do it through the proper channels. That's not frivolous conduct. Frivolous conduct, at least for Rule 11, is defined as the willful violation of the rule. And under 2323.51, it has to be something that no reasonable lawyer would bring. And I certainly see a valid argument here against subject matter jurisdiction or personal jurisdiction, however you want to look at it. But a valid argument here that's being pressed vigorously in what is a very contentious family feud over this, with my clients hardly being the sole instigators of anything. Everyone's got, you know, a battle going on one way or the other. And in this case, they have legitimate grounds for making this and pressing this jurisdictional argument throughout the course of the proceedings because it did affect virtually every issue that came up. I would just then point out, going to our third assignment of error, which deals with specifically the fees that were awarded. Two problems here. The first is that under 2323.51B1, the motion has to be filed within 30 days of the final judgment, and every one of those guardian appointments was a final appealable order. It's a special proceeding, and that's the Thomason case, where that was established in connection with the divorce proceeding, but the analysis is the same. So that cuts it all the way back to a very brief period of time where sanctions could be awarded under 2323.51 if there was frivolous conduct. And the fees, at least it appears to us, are based primarily on appeals. I didn't check every one, but the appeals they're talking about, to this court in particular, there was a finding at the end of each one that there were reasonable grounds for the appeal. So during the guardianship hearing, Exhibit 5, it was this court's decision that came out on August 2, 2001. In this case, Judge Sutton authored it, and at the top, very last page, there are reasonable grounds for this appeal. Yet, the probate court decided to impose fees and sanctions because this was frivolous in his view. That is not his authority. If they want fees for a frivolous appeal, they need to go through the appellate rules governing that. So with that said, we would urge this court to find that there was no jurisdiction to issue the sanctions order. There was no reason to issue the sanctions order because there was no frivolous conduct. And even if you agree with the probate court on all of that, this fee award needs to be cut down substantially. Thank you.
Thank you, Counsel. You have full time for a moment.
Good morning. I'm Eric Sabrins, representing the guardian of Fourough, Bakhtiar, attorney Zachary Simonoff. May it please the court. I don't know where you could have a more textbook example of repetitive, frivolous motions, arguments, and multiple appeals to this court, as well as to the 8th District Court of Appeals in Cleveland, arising from arguments that had been repeatedly heard and overruled and still have the same arguments, the same claims, the same contentions, the same appeals being falsely, disingenuously, and egregiously brought back again and again. That is the textbook definition, as I say, of frivolous conduct in violation of RC 2323.51A2 and willful violations under Civil Rule 11. As the Supreme Court said in the DeFranco versus South Euclid case in 2015, an argument or claim is frivolous if it's clear under existing law or under a reasonable extension or modification of existing law that no lawyer could make that argument. And that's exactly what presented itself on multiple occasions, not only to the probate court, but to this court. This court has overruled these frivolous jurisdictional contentions several times, as did the 8th District Court of Appeals when it was raised in the divorce case that Mrs. Sagafi, Ms. Bakhtiar, had brought in Cuyahoga County. The conduct in this case was much worse than the 4 times the Stafford Law Company filed appeals to the Ohio Supreme Court on the proposition that denying a continuance of a trial date is an immediately appealable final order. The Ohio Supreme Court held less than 3 months ago that those appeals, the 4 times that they were separately brought up to the Ohio Supreme Court, was frivolous conduct for exactly the test that I described a second ago, because they were neither warranted by existing law nor supported by any good faith arguments for the modification or reversal of existing law. And what did the Ohio Supreme Court do? It provided exactly the same sanction in that case. The case I'm referring to, by the way, is HR versus PJE. And the slip opinion appears at 2023 Ohio 4185, November 22nd of last year. The sanction was the award of reasonable attorney's fees that were incurred as a result of the frivolous conduct. And that is precisely the standard that the probate judge applied in this case in awarding reasonable attorney's fees against the two lawyers who should have known better, should have understood their professional and ethical obligations under the Civil Rule 11 standard and under the RC 2323.51 standard. As the 11th District said, and we cited this case in our brief, as with the DeFranco case, Fast Property Solutions versus Jurchenko, an 11th District case in 2012, while zealous advocacy is to be admired, conduct that crosses the line separating zeal from patent frivolousness is sanctionable rather than admirable. That's what we have here. To raise an issue on jurisdiction once, perhaps even twice, in the face of it being overruled the first time, is zealous advocacy that one can recognize and one can admire. But to raise it 5, 6, 7, 8, and I stopped counting at 9, separate times, both on the trial court level and on the appellate level, crosses the line, not even a close call in my submission to the court. Crossing that line from zeal, admirable zeal, to patent frivolousness and sanctionable conduct. Now, Mr. Flowers says that it wasn't a timely request for sanctions under 2323.51 because it wasn't within 30 days of the final judgment in the case. There's a difference between the statutory language of final judgment for purposes of 2323.51 and what is an interlocutory order that is nevertheless appealable under 2505.02. And that's what we had here. We had special proceedings that were appealable. There was no issue of appellate jurisdiction in those multiple appeals because they were interlocutory orders subject to appeal because of those special provisions in the appellate statute. That has nothing to do with whether there's been a final judgment, whether the motion was within 30 days of that final judgment. Indeed, there has not been a final judgment entered in the guardianship case as we sit here today. So it was within 30 days of a final judgment because there was no final judgment yet ordered.
So you would say in guardianships and estates, there's no final judgment until the guardian is terminated by death or by appointment of another dispensation of the guardianship, or in the estate when the final estate is resolved?
Yes, Your Honor, when they're closed. When they're closed with a final judgment or order. And that for purposes when you have frivolous conduct in such a guardianship or estate proceeding, that would be when the 30-day rule attaches.
Would you say if someone wished to file for sanctions prior to that, they could?
Yes, sir, absolutely, because you're still within 30 days of a final judgment that hasn't happened yet, absolutely. Now, you heard from appellant's counsel that in the 4 days that he has been involved in this case, he couldn't see whether there was evidence in the record that the ward had been served. But there was a factual finding by the trial court that the ward was served. And that factual finding was that Paula Strickler, as my friend indicated, who was the probate court investigator, served the ward and filed a return of that service on May 30th of 2013. The first hearing on the appointment of the first interim guardian was on June 6th of 2013. So even though the service requirement doesn't apply to interim guardians being appointed, it only applies to the hearing at which a final guardian is appointed. In fact, the ward was served more than 7 days before the first hearing on the appointment of the first interim guardian. That was June 6th of 2013. Then...
Continue, go ahead, I'm sorry. Continue.
Yes, Your Honor. Then on November 25th of 2013, where the ward appeared at the hearing with her counsel had entered an appearance the month before. When Mr. Wolf and the ward appeared at that November 2013 hearing, and the second guardian was appointed, her daughter Jayla Prizzuto, and an accountant named Steven Sarchev. Mr. Simonoff then replaced Steve Sarchev later on. But the ward and council both appeared at that hearing, and the ward consented on the record to the appointment of the second interim guardian and to the guardianship. How much more jurisdiction can one ask for than service, appearance, obviously notice of the hearing, appearance at the hearing, and consent? And not only that, there was no objection made at that hearing or at any time before these two lawyers came into the case representing Bakhtiar Sagafi to this jurisdictional argument.
Going back to the first hearing that you were referring to where the interim guardian was appointed.
The
Was
first
that
one, yes,
hearing
Your
just scheduled pursuant to its notice for the appointment of interim guardian, or was that just a hearing on the application for guardianship at that time, do you know, for the record?
I believe, Your Honor, it was on the notice of appointment or commencement of the guardianship. But there was nothing done at that hearing other than the appointment of the interim guardian. So there was no evidence presented, by the way, at the then October 2014 RC 2111.02C hearing. That's the hearing that requires the service of the notice that had been done over a year before. There was no evidence presented by the attorney who showed up at that hearing representing Ms. Bakhtiar's husband, Mehdi Sagafi. No evidence presented by him, no argument by him that there was anything improper about the hearing or lacking jurisdiction of the hearing. And Bakhtiar Sagafi, the client of the two attorneys who are appellants in this case, didn't appear at that hearing, even though he had filed a request to be appointed guardian of his mother. So the jurisdictional argument is only the first of 8 or 9 different repetitive and frivolous arguments that they have made over and over again, multiple motions, an argument that the guardian was trying to frustrate visitation with the ward and isolate the ward from her family, even though no one in the family, even though the guardian took great steps to make sure that there were visitation rights accorded to the family by order of the probate court, visitation as frequently as they wished. The family members didn't visit with their mother, not even on her birthday, not even on Mother's Day, from 2016 until she was moved from the nursing facility where she was living to another son's home, Dariush Sagafi, in 2022. There had been no visitation for 6 years, and in fact, Bakhtiar, these lawyers' client, testified in 2019 that he hadn't seen his mother in years on advice of his lawyer, on advice of Charles Longo. And yet they tried multiple times to blame that on the guardian, even after that had been overruled repeatedly. They appealed attorney's fees that the probate court awarded to Jayla Prizzuto's counsel, even though they filed no objection in the trial court to the fees. That was something that this court dismissed that appeal or denied the appeal because there had been nothing filed in the trial court. They moved to disqualify Mr. Simonoff as guardian on multiple occasions, having been previously overruled multiple times. They even did so, they filed a motion to disqualify him as the guardian 3 weeks after the probate court had denied the identical motion, 3 weeks, with no new arguments, no new evidence, no new basis being presented. They moved to disqualify me and the ward's attorney, even though they had no attorney-client relationship with either me or the ward's attorney. And that was overruled and upheld on appeal for that reason. 10 out of the 32 filings that we described across 4 pages in our brief related to access to the guardianship file, insisting, demanding that they had a right to see the guardianship file as a public record. And this was after Attorney Longo already had the entire guardianship file, that they filed these 10 frivolous motions. They took exceptions to the 4th and 5th partial accountings in the guardianship, even though the probate court found that there were no basis presented for those exceptions other than merely to delay and frustrate the orderly proceeding of the guardianship in the probate court. I can go on and on and on.
I will let you know you have a minute left as far as going on and on, counsel.
Well, that gives me exactly enough time, Your Honor, thank you. As I said at the beginning, if there was ever a time for imposing sanctions, this is certainly it. But the law is that this court reviews the decision of the probate judge on an abuse of discretion standard. And given the overwhelming reasonable basis in the evidentiary record that is before you, the probate court did not abuse its discretion in finding that appellants had engaged in frivolous conduct under RC 23.51A2 and had engaged in willful violations of Civil Rule 11, justifying the imposition of the sanctions of the attorney's fees incurred as a direct result of having to fight all of these frivolous motions. And that was the evidence that the probate court heard, not only from Mr. Simonoff, but from the expert that we hired, Giovanna Bremke, who testified again without contrary evidence in the record. So I ask the court please to affirm the well-reasoned decision of the probate court. And I thank you.
Again, counsel, have your full 3 minutes for rebuttal.
Thank you, Your Honors. I'm going to start out with jurisdiction because I think it cuts through everything here. There is no case from this court resolving this jurisdictional question. If this issue had been resolved previously, they would have cited it in their brief and I would have acknowledged it. It's not in their brief. They don't claim there's a single instance where this court resolved this issue. The 8th District got into jurisdiction on the domestic relations case dealing with domestic relations jurisdiction. I'm not sure why we're talking about that because my clients weren't involved with that. They got involved later. We agree now at this point that this guardianship, the law was not followed from the start. We had 2 interim appointments, supposed to last 2 weeks each. They last well over a year. Then we finally get the appointment 14 months into this. Now,
Let me ask you to follow the same question I asked counsel. That initial hearing where it seemed to be the investigator said, I served this person 7 days before the interim appointment hearing.
right.
Was that specifically for an interim appointment hearing? Was that for just the notice of the guardianship itself being filed? What was the point of that notice?
Well, all I can go by is what I see on the docket, and that's obviously what this court can go by too. It had to be the interim appointment, because that's all that happened. And so looking at that date, and I'm not sure we have the entire docket. I know the court does, so there may be more in there I don't have. But if you look, it was filed on May 30, 2013. It's just the investigator's report. And on the second page, and this is I think what they're talking about, she's got a part that says service of notice, and she just checks the box. There's nothing in here that says that a hearing was set. There's nothing in here that says
Counsel indicated there was a finding by the court at that time that the warrant was served.
yeah, boilerplate. And I'm not sure if it was that time, but he has it in there. It always says, everybody who's required to be served was served, period. That's on appeal. It's now for this court to determine as a matter of law, was he correct? Because he can't bootstrap his own jurisdiction by saying like, oh yeah, we did it, I got jurisdiction, you know, nobody can change what I'm gonna do now. He has to follow the law.
Is that really what's on appeal here though?
Yeah,
Subject matter jurisdiction, or is it whether the court should have granted sanctions?
right? Because if he didn't have subject matter jurisdiction, he couldn't grant sanctions. All his orders are void ab initio.
So ironically, is it appropriate we're relitigating subject matter jurisdiction again here?
I don't think we are relitigating. As far as I'm aware, this issue is coming up in this court, in this case, for the first time. As far as I'm aware.
Is it listed as an assignment of error?
Yes, first one, correct.
That standing as, that subject matter jurisdiction is an error?
Right, yeah, exactly, and we cite the Corliss case, we cite the Swartz case, you know, both of them say this is subject matter jurisdiction, both of them say they have to adhere to this. And they're not arguing with our authorities, they're coming up with this idea that, well, by the time we appointed a permanent guardian, she had a lawyer and everybody agreed and she waived. There is no case law that says that's okay. There is nothing in the statute that says that's an exception. The statute actually says the ward cannot waive service, that's section C, and that's very important. Because what the statute is trying to avoid is the situation where certain family members kind of get the incompetent to, on the record, agree to certain things and get their way. And that's the allegation here. Certainly the allegation, the Sixth Circuit decision makes that very clear, where the court declined to award sanctions.
If you wrap up, we're about time to go. Thank you.
But again, this is very analogous to a civil case. We wouldn't be standing here talking about whether or not if service hadn't been perfected, there would be no excuse. Under Gleazo, you'd have to have a dismissal. Here it's more important, because more is at stake. So we'd ask you to find that there's no subject matter jurisdiction here, and that the awards need to be reversed. Thank you.
And thank you both for your presentations. The court will take the matter under advisement and will issue a decision in due course. You know, the clerk of court will mail a copy of that decision to you on release, and also the decision will be released on the Ohio Supreme Court's website.